Mayo, have you connected? That's what. Are we ready? Yes. Yes.
Matter is stated for
Yes.
respectfully, my name is Ogaz. It is Esther.
The first.
Ubechi Ogaz. I appear with Esther Ajekibe for the claimant.
If it pleases your lordship, Oluwaseyilayo Ojo, I announce appearance for the defendants. Appearing with me, my lord, is Adedayo Ogunshowo. Adedayo Ogunshowo. May I suggest the echoes can be stopped if it's muted? If the sound is muted.
Yes, Counsel. Yes, can I hear? You said something.
No, I was going to suggest to my lord so as to stop. I think the echoes have stopped. I was going to make a suggestion. Okay.
Yes, Mr. Ogazi.
My lord, the matter is slated for hearing. The claimant is ready and available to testify, and subject to the court's convenience, we are ready to proceed.
Just one moment. Registrar, do we have extra paper? Yes.
My lord, I concede. We're also prepared to proceed. But before we proceed, my lord, may I be guided by your lordship? I'm a bit confused. Maybe we need to tender documents by consent, or how we intend to do it in terms of tendering evidence. If your lordship could be so kind as to guide me. Seeing as the witness is not here and how we're going to tender the documents, I am comfortable, if your lordship is disposed, for us to just tender by consent. But I do not know if the witness has the documents with her. I wouldn't know.
Yes.
And what documents the witness has.
Yes, Mr. Gazi.
My lord, we agree that documents can be tendered by consent. I only want to add that my lord pointed out at the ruling ordering virtual hearing on the matter that any objection should be taken at the address stage and not at this stage. So in view of that, I agree with submission by counsel to defendant that documents can be tendered by consent.
Yes. So, Mr. Ojo, are you okay with that now?
My lord, I'm
I
sorry.
said, are you okay with that?
Oh, I'm comfortable with that. I just
so
wanted
any
to be guided.
objection you're going to raise will be at the address stage.
I don't have any objections.
No objection to
As
that.
I've seen the documents, as long as they're the documents front-loaded, I have no problem with them.
Okay.
I just wanted to be properly guided as to how we'll tender it.
Okay.
I'm grateful, my lord.
Yes. Yes, Mr. Gazi.
In view of that, we are ready to have our witness take a stand.
Okay. Yes.
So, Martha, are you there?
Yes, I'm here.
Yes. Okay.
Can you hear me?
Yes. Hello, can we proceed?
Yes, you can.
Okay. Martha, can you tell this court your full name for the record?
Yeah, it's Martha Da Costa Sherwood.
Your address?
218 Firhill Road, London,
His name
SE6
is what?
3LL.
What is the name?
The court is asking, what is your name? Can you speak louder?
Yes, Martha Da Costa Sherwood.
You are the claimant in this suit.
I am, yes.
Can you tell the court your address?
218 Firhill Road, London, SE6 3LL.
Your address is 218
Firhill Road, FIRHILL.
Fairhill. Yes, I know that.
Road,
Okay.
London, SE6 3LL.
Do you recall making a statement before this court on 19th of December 2019?
Yes, I do.
What would you like the court to do with that statement?
To accept it as my statement for this case.
Okay. In your statement, you refer to certain documents, including your employment contract. You also refer to the school's, that's the defendant, personnel handbook. You also refer to email by Mrs. Atuanya and a letter terminating your employment.
Yes,
You
I
made
did.
references
Yes.
to those documents.
Yes, I remember.
Okay. My lord, will apply to tender those documents in evidence, my lord.
My Lord, I have no objections. And perhaps while we're on the subject, I may as well just present that for the claimant so that my Lord might just take them all in at once, since we don't have any objections. Sorry, that's for the respondent as well.
No.
The set of documents for the respondent.
No, we are dealing with the claimant's case now.
As the court pleases.
Yes, so you haven't, we have to take the documents, mark them, and then do the cross-examination.
Okay, I just thought since we were tendering by consent and there are no objections, everything could go
The defendant is not in court. It's not online, you see. We're talking about
the defendant is online, actually.
Okay, the defendant too is online.
Yes, my
yes,
Lord.
but this is just about the documents.
Okay, no. We let's deal with the claimant's case.
I will be guided. I'm guided by your lordship. I'm grateful.
How many documents are there? 4. Okay, let me know. Let me see them. Yes, Mr. Gazi, when did you file your documents to be relied on? What did so I can?
We filed the documents. We front-loaded them on the 19th of December, 2019, my Lord.
So you have 4 documents.
We have 4 documents. We also put in certificate of compliance.
No, that will not form part of the document, but the court will take it because that's just in compliance with Section 84 of the Evidence Act.
As the court pleases.
Documents tendered by claimant witness, admitted in evidence and marked as exhibits MS1 to MS4, and they are marked as follows. Claimant's contract of employment dated 10th February 2017 is marked as exhibit MS1. Defendant staff handbook MS2. Email received from Mrs. Amaka Atuanya MS3 and termination letter MS4.
My Lord. Just for the record, I know that the claimants and the defendant counsel do not object. But just for the record, I will be asking the claimant. The document just tendered, they appear to have been printed electronically. What of the hard copies? How?
They were all received.
It seems
we cannot hear you. Did you mute? We can't hear you. We can't hear you.
They are all received soft copy.
We can't hear you.
What haven't changed.
Yes, what happened? It's not what? Which one? It's showing. It's showing, but we cannot hear the claimant. What's the problem? My own. Oh, why? But it was showing, I was showing before. Just one moment, I'm trying to connect with my iPad.
As the court, please.
Yes, is it okay now? Because I'm connected.
Can you hear me now?
Yes, Clement, can you hear us?
I can hear you. Can you hear me?
Yes, Clement.
I can hear you. Can you hear me?
Okay.
My lord, the echo.
I don't know why it's echoing. Why is this echoing? It's okay now. Can you hear us?
I can hear you.
Okay, let's go.
So, Martha, I asked before the interruption. I said, for the records, the documents, they appear to have been processed electronically. Can you confirm that? How about the hard copy, if any exist?
No, yes, they were all received soft copy.
Can you say that again?
Yes, they were all received electronic. They were received, sent to me electronically.
Okay, thank you.
Yes.
Hello, that will be all for the claimant.
Yes, Mr. Ojo.
I'm grateful, my lord.
How many minutes do you think you need for cross-examination of the claimant's witness?
I actually believe that the case is very, very much borders on interpretation of the contract. So my questions are very few.
Yes, yeah, can we start? Yes, can we start, Mr. Joe?
Good morning, Ms. Sherwood.
Good morning.
How are you this?
I'm well, thank you.
I know it's been a bit of a long haul since 2019, and we're where we are today. I just have a few questions for you and make them pretty direct. And I expect just yes or no. Are you able to?
Yes.
Thank you
Yes.
very much. Now, I just want to confirm, Ms. Sherwood, are you aware that your contract of employment stands on a pedestal different from those of other staff in the school?
I don't understand.
Thank you. All right. So basically what I'm saying is that you are employed patriot staff, correct?
Correct. Yes.
So your terms of employment are not the same as those of local staff, correct?
I'm not fully aware of the contracts of the local staff.
Okay. That makes sense because that's not your contract anyway. Okay. Now, CIS or immigration responsibilities for you, is that correct?
Correct. Yes.
Are you aware the
CIS immigration what?
responsibilities? So are you aware that the work permit is tenured? It's given till a period of time.
Yes.
So if that period expires during the course of your employment, CIS will be obliged to renew, correct?
Yes.
So that means that if it expires after the period of your employment, CIS is not obliged to renew. I can rephrase that.
Yes, please.
All right. So what I'm saying basically is this, Ms. Sherwood. If you're no longer in the employment of CIS, CIS has no obligation to renew.
Yes.
Thank you. Are you also aware that the contract of employment that you have with CIS can be terminated without notice?
Yes, on certain grounds.
But you're aware it can be terminated without notice?
Yes, on certain grounds.
You say on certain grounds. Will those be the grounds stated in paragraph 13 of your contract of employment?
If you read that paragraph, then I would be able to confirm.
Okay, maybe I should ask, do you have any documents with you there?
I do.
All right, so the contract of employment that you have with CIS.
Yes.
My lord, if I may interject, I'm not fully aware that the claimant has access to the document in question.
Just told the court that she has access to the document. She just said, I have the document before me. You're not going to speak for her. It's cross-examination and she's expected to answer questions put across to her.
As the court
Continue because she has documents. So if there's any reference to any of the documents, she'll be able to refer to it.
as the court pleases.
Yes, I just want to confirm, Ms. Sherwood, that we are speaking to the same document. Will that be the document dated 10th of February 2017?
My contract letter?
Yes, please.
Yes.
Okay. So you said if perhaps I will read out the paragraph, it might refresh your memory.
Yes.
So when I speak of paragraph 13, I speak to the paragraph that says, however, the employer shall have the right to terminate the contract of the employee without notice on the following grounds. Is that the one you?
Yes.
So we're speaking to the same paragraph then. So to go back to what you said earlier on, you're aware that it can be terminated without notice under that provision.
Yes.
Whether, albeit with respect to certain grounds, but under that provision.
Yes.
Thank you. Now, one of the grounds which are stated in that document, and I will just read them to you, specifically ground D and F. D states willful non-compliance with school regulations or violation or defiance of lawful orders or directives given by the employer. You confirm that as one of the grounds.
Yes.
And then the last one, for any other reason which in the opinion of the employer is considered to be detrimental and adversely affecting the school's image. You confirm that as well?
Confirm.
Thank you. Now, you will agree with me, Ms. Sherwood, that those provisions are somewhat subjective.
Yes.
Now, paragraph 2 of your contract, or rather, let me just ask, you're also aware that the school expects you to comply with the directives issued by management?
Yes.
Some of those directives might come from the head of school orally to you, correct?
Yes.
Let me ask you this. Have you looked at the papers that the school has presented in defense to your claim?
Yes.
So I will also be right to assume that you have read all the email exchanges that were attached to the documents.
Yes.
These were all email exchanges between yourself and the school. Is that correct?
I believe they were. I think there may have been other exchanges in those documents.
I'm sorry, I missed that.
I think there may have been exchanges with other parties in those documents.
Just one last question for you, Ms. Sherwood. And I'm sorry to take your time on this. I know it is a sore, but I just want you to confirm to the court, your employment was never confirmed.
That's incorrect.
Beg your pardon?
That's incorrect.
Okay, your employment was confirmed.
Yes.
My lord, just to guide the court, counsel to defendant made reference to certain documents that they exhibited and asked the claimant whether those were exchanged between her and the school.
Are we of any documents that did the counsel to the defendant refer to any document apart from the documents tendered before the court?
Yes.
My lord, the only question I put to the witness is if she had seen the processes that we filed in response to her case. And the witness said, yes, that's all. I haven't referred to any specific documents.
Yes, Mr. Gazi, which are you referring to?
My lord, the next question defense counsel asked the claimant was whether the emails were the exchanges between her and the school.
Which email? I'm sure he's referring to the emails. That's the email tendered by the claimant.
No, he was referring to the email part of the defendant's bundle.
The defense counsel cannot ask that because that document is not before the courts.
In view of that, my lord, I applied that particular question and the answer be expunged.
If Just let me hear from Mr. Joe.
My lord.
What email trail? Which documents were you referring to?
My lord, the witness had said that she had read the documents. So my questions were staged. I asked her, did this contain email exchanges? She says, yes. I haven't been particular about any email. And I just said, have you read them? That's all.
Which of the emails are you referring to?
My lord, the bundle.
Standard emails, which has been marked?
Certainly not. My lord.
Which email are you referring to?
So I asked about the documents attached to the statement of defense. And the witness says she has read them. That's all. I wasn't particular about any documents.
So let me tell you, if I am writing judgments.
Yes, my lord.
And claimant document, that is the document I intend to deal with, because now we're talking about the cross-examination of the claimant. I will only deal with documents before the court. So if you are referring to defense documents, I'm not going to go and then start documents through. So I expect that you would have asked questions that deal with documents that be marked accordingly by the court. It is only those ones the court can look at. And it's only when it gets to the defense that the defendant can tender documents through their witness, and then questions can be asked on that. If you ask her questions about that, the way I have put it, I am not going to look at the defense counsel's documents when I am writing judgment at this time. I'm going to treat both documents separately.
As the court pleases. I've taken
I'm going to just zero in into documents that have been marked before the court.
No, my lord, the witness.
Because you have opportunity when the defense comes on.
As the court pleases.
For you to ask questions at large.
Yes, but if I may just one little clarification.
Yes.
I have not asked the witness about any specific documents. Now, my lord, I have not. That's the point I'm making. That's the point. All I did, because my lord knows that she has brought the defendants to court and they have responded. So I'm just curious to know that the witness understands and has seen the defense. That's all. And that she confirmed that much. Every other thing, I won't refer to a document that your lordship does not have before her. I will not. I will not. And like I said, it was my last question. I said it was the last question I want to ask her. You know, so she says that it is not correct. Oh, Ms. Sherwood, maybe I should ask again. I said that your employment was never confirmed. And what was your response, please?
That's incorrect.
That is
incorrect.
Good.
Yes, any more questions?
That is all for the witness. Ms. Sherwood, thank you very much.
Yes, any reexamination?
Yes, my lord.
Yes.
We just have one question for re-examination, and it arises from the question by defense counsel on the defense processes. Okay. So, Ms. Sherwood, counsel to the defendant asked you if you have seen the statement of defense.
And she answered that correctly.
Yes. My question to you now is, on review of the statement of defense, did you in any way cite any document or information that you do not agree with?
This is not a question. Okay.
Mr. Gazi, I'm not going to put that question down. I'm not writing. First of all, when you talk about cross-examination, it has to be questions from the other side. And then Mr. Joe has clarified that the question, because I asked him the question whether he's referring to the court. If he's not talking about the claimant's document before the court, then that question goes to no issue. Do you understand?
Yes, as
Yes.
the court pleases.
If we are going to keep talking about this and overflogging the issue, if the document is not before the court and the question is asked about it, there's nothing the court can do. I'm not a witch. I can only deal with documents before me. And when I'm writing a judgment, I'm talking about the claimant's case. I talk about the documents before the court and the documents that have been marked, not those that are supposed to be marked or those that the court ought to know about. The court ought not to know about anything. What the court is concerned with.
As the court pleases.
So what I'm saying is that re-examination will not come in now. Because you're talking about, I have told Mr. Ojo, if he's talking, yes, the claimant admitted that she has seen the defense processes. Yes. And then he asked the question, email trail or whatever. The defense email trail is not before the court. So if you ask the question on that, the court is not going to deal with it.
We are properly guided by the court.
So any other question on re-examination?
No other question.
Put it that there is no question for re-examination because that's your first question. I'm going to put it as nil.
We are comfortable with that, my lord. We are comfortable. We are grateful, my lord.
So is that the case of the claimant, or do you have another witness for the claimant?
My lord, we don't have any other witness. That's the case of the claimant.
Yes. So I'll give a date for the defense. Yes. How many witnesses do you have, Mr.
I have one. I had hoped that I would have her coming today, but it was not possible to make that arrangement. So I was going to appeal to your lordship for a date anyway. So I'm grateful that my lord is considering it. I don't know how early my lord can accommodate us.
Even the May dates for trial. May dates, yeah.
And here I was trying to be ambitious and think I can come back in 2 weeks.
No, you can't even go back in 2 months.
Wow. Okay.
So
I will be grasping by the straws here, but can I appeal to your lordship very early next year?
That's available, the registrar.
I'm grateful. I'm grateful. And I'm appealing to the registrars as well.
Yeah, 10th of 2023.
Wow. My lord, if that is what is convenient for your lordship, we don't have a choice. My lords will accept it.
Is that going to be well, or we're going to do the defendant?
The witness can come in person. Yes.
So we take a 10th of May.
10th of May. If there is need, if for any reason the witness would not be available, because ordinarily she's around now, I would inform the court much earlier, my learned friend. I would do the needful. I would not put the court in any difficulty on that day.
No, if you have taken a day, whatever way the witness, the defense witness chooses to come,
okay,
it's going to keep to the May 10th date.
Okay, no, that's fine by me. That's fine.
Hello, 10th of May is also convenient for us.
This matter is adjourned to May 10, 2023 for the defendant to open its defense.
As the court pleases, my lord, we're grateful.
We're also grateful, my lord.